So this is about who should be the administrator of a Louisiana succession. So when somebody dies in Louisiana and they have assets in their name, if they had a will, they will have likely have named an executor of their will. But if they didn't have a will and they had assets in their name, maybe a home, maybe some investments, then there's a determination as to whether there's going to be what's called an administration of a succession. If stuff needs to be handled while all this is going on, then it's likely that bills need to be paid, access to accounts needs to be taken care of. Then it's likely that an administrator is going to need to be appointed for that succession. So who should the administrator be? Well, it can be a surviving spouse. It can be one of the children. In fact, I've handled so many over the years. Oftentimes, maybe dad's the surviving parent, or maybe mom is, and the 4 children are in the office here, and they're starting the process to get that surviving parent's estate settled. And I might say something like, well, because accounts are frozen and, things need to be taken care of on behalf of your parents' estate, there needs to be an administrator appointed. Which one of the 4 of you, if we needed to get the court to appoint someone to be the administrator of the succession, which one of you should it be? And most of the time, 3 of the 4 children will, point to that one who just kind of has been handling everything. So that's sometimes just the way it shakes out. And again, that administrator's role is, once they're appointed by the court, to go perhaps open an estate account, collect the funds from the accounts that are frozen, move those funds into an estate account that the administrator can sign on that account. The courts oversee it. So, now the administrator can pay bills, can pay expenses, and, has lots of authorities that they wouldn't have had an administrator not been appointed. So sometimes, a spouse is often an appropriate administrator. An adult child, particularly when they have the support of the other children, is really an ideal administrator. Sometimes somebody dies and they co-own property with someone else. Sometimes that someone else wants to get that co-owned property sold. So sometimes we see a co-owner of property petition a court to be appointed as the administrator of their co-owner's succession so that property can be sold. So anyway, it's important that you get the right administrator, and it's important that all of the heirs support that administrator, support them in a way that they can be what's called an independent administrator, which makes it easier to get things done. Not every step has to be approved by a judge. So there's some of your factors there in getting an administrator appointed. Again, that's the case when somebody dies, they have assets in their name, they're frozen, and they didn't have a will, because if they had a will, they would have appointed an executor. But when that's not the case, then an administrator or a potential administrator has to petition the court and ask a judge to be appointed the administrator. And there's all kinds of rules if someone wants to oppose that appointment, what they have to do. But much easier to get things done if everybody's in support of that administrator. Hope that helps. Time to go take care of business.